The unlawful presence bars generally apply to people who have accumulated more than 180 days of unlawful presence in the U.S., leave, and then seek admission back to the U.S. again. So, for example, someone can come as a student at a Big Ten university, finish their studies, and then stay for a long enough period, let's say 8 months, leave back to their home country, get a job at a prominent company, and be barred from employment and a green card because of unlawful presence. The Immigration and Nationality Act, which is the code that Congress created driving immigration law, does contain waivers to the 3 and 10-year bar if an individual is able to show extreme hardship to a spouse or a parent who is a United States citizen or a green card holder. Now, this waiver scheme does not include or consider similar hardship to a child who is a U.S. citizen or hardship to oneself. Extreme hardship is not defined in the immigration statute or in the regulations. Rather, it is guided by case law, and the case law has interpreted extreme hardship quite rigidly and to include something more than the normal hardship that might be caused by separation. Some of the factors that an agency will think about or consider in deciding whether an anchor relative will suffer extreme hardship are financial, cultural, medical, educational. So, to use the example of Maria and Matthew, if Matthew has a serious medical condition, then Maria might document this fact and her regular care for Matthew to show that her U.S. citizen husband will suffer extreme hardship if she remains separated for a long period of time. So what's the solution, right? We have these arbitrary bars that apply to people who may have no criminal history at all, and in many cases are legally eligible for status as a green card holder. One solution is legislative, and it's been at least part of the conversation around immigration reform, and that is to repeal the bars, to end the 3 and 10-year bars altogether. They were never part of the statute before 1996, and they can be just as easily struck. A less ambitious solution might be to change extreme hardship to regular hardship or a public interest standard, or to expand the hardship to self or a USC child. Beyond the halls of Congress, there are administrative solutions that might be employed. The United States Citizenship and Immigration Services could employ a less rigorous standard for extreme hardship and simply interpret extreme less extremely. Another solution might be to grant a form of prosecutorial discretion, like parole in place, to people who would otherwise face a bar and are here. The main policy reason for doing something is that the unlawful presence bars are arbitrary, or at least unrelated to whether or not the individual affirmatively qualifies for relief or a benefit under our law and is otherwise contributing to the U.S. in meaningful ways.